Hi, I'm Flo from FM Legal. I'm a compulsory acquisition specialist, practitioner in New South Wales mainly. Legal costs are probably the one thing that everybody wants to know about in a case, and what is the position on costs. The answer should be very simple, because under the Just Terms Act there is a very clear provision and a right to have legal fees paid. It refers to reasonable legal fees, of course, but as lawyers we're also obliged anyway, under other laws, to only charge what is reasonable. In addition to legal fees, there's another section that says you're also entitled to valuation fees on top. And this is on top of what you get for the market value of your property and all other claim rights that you have. So it should be fairly obvious to any acquiring authority that they have to pay for the lawyers. But of course, what is always an issue is, well, what is reasonable? And there are no guidelines that actually apply. So it really comes down to, quite frankly, the view sometimes that the acquiring authority takes, based on sometimes extensive experience. So if you're dealing with an authority that has had a long history, such as Transport for New South Wales, you will not have an issue in recovering reasonable legal fees, because they have dealt with it for years. They've dealt with all sorts of law firms, all sorts of cases, and they know the sort of costs that should be involved. So generally speaking, if I have a matter with Transport, I can give a client a guarantee that we're going to recover all of our costs, and there is no cost to a client. However, if you're dealing with an acquiring authority such as a council that really has very limited experience, or alternatively just has a view that they just don't want to pay what it is that the legal bill is, and that happens and I see it, then you can be somewhat stuck, because they might eventually offer you an amount that you want to accept for your case, but in terms of the amount that they want to offer you for your legal and valuation fees, you may not want to accept that. And in that case, the only option you have is actually getting a Valuer General's determination made, but they won't make a determination just on the fees, they want to make a determination on everything. So we have to be very careful and make sure that you as a client fully understand what the position is, but also we seek to recover all of your fees against the acquiring authority, but we need your help and support to be able to pressure them to actually pay all of those as well. Because otherwise, if they just say, well, we're just going to offer you $4,000 and the bill was $20,000, I'm in a position, I'm experienced enough, I've been doing this for many years, to say that that's not reasonable. And I can explain myself and demonstrate what it is that we've done. You will know that as the client as to what it is that we've spent the time doing, and you will see it. And we frequently will have to demonstrate that and explain that to the acquiring authority. And 99% of the time that's fine, and they get it, and they will eventually pay that. But there's a couple of acquiring authorities who recently have just said, well, we don't really care what you spend and what you do and whether it's reasonable. And they haven't put it in those words, but that is the effect of what they've said. And they said, well, we're going to limit it to, $4,000, tough luck. So unfortunately, the Act gives you these rights, but if you are reaching an agreement with them, then you can be stuck in the same way that you can be stuck on where they go to with the market value. If you've got a property that we are saying to you, well, look, you will get more if you go to a determination on this, but you decide to accept less, that is your decision as a client. It is your case, it is not my case, it is your decision. So sometimes clients will say, well, look, I just don't want to go with this determination. I prefer to accept less, even though I know it's not the full amount, but I just want it over and done with. And that can impact on the legal fees recovery. So far as what I can say is that we give a guarantee that if you follow our advice, you'll be able to recover all of your costs. Because in every matter that I've ever had that went to the Valuer General's determination, we have been given 100% of our fees. So that shows, certainly, objectively, that somebody has looked at our costs in that sense and said, yes, these are all reasonable. And these are matters where sometimes the acquiring authority will object and they say, oh, that was excessive, you shouldn't have spent that amount of time doing it. Well, that's not the case. We know what we're doing. We're here to do our job well and to do it reasonably. We are not here to charge excessive amounts. That doesn't serve anyone's purpose, doesn't serve my purpose ultimately, or my reputation, and it doesn't help me with the client, because I do not want to have an issue over the cost. It just shouldn't be an issue. So luckily in the vast majority of cases it's fine, but there are some where you just have these hurdles that you hit, and it's usually with this council or some government body that just hasn't dealt with this quite a lot of times and doesn't appreciate the complexity of it. Just moving on away from legal fees and onto other fees, there can be other costs that arise in your case. Guarantee that you're always going to have a valuation fee. Again, that's covered under the Act, that you are allowed to have a valuer and their valuation fees are covered for payment, but exactly the same thing can happen with valuation fees. So this is a very complex area of law, and it's nothing like getting a bank valuation, which I think in modern days is probably even a few $100s, if even. The cost for valuers are many, many thousands in a compulsory acquisition case, and it's because of the complexity, but also because of the fact that the vast majority of time it is not just a valuation report that is done and then is just given to you. It is a continuous matter. You can have sometimes multiple drafts of evaluation over a period of time of say 6 to 12 months, because you as a client may want an indication of value when the matter starts, but then we have to wait for the offer. Then there might be numerous other sales that happen, and there's a constant update and a change. So I describe evaluation as sometimes as something that's like going around in a washing machine, and at what point are you going to stop and say, well, this is the date? It doesn't stop. That washing machine cycle continues until the day that you either reach an agreement, and that's supposed to be the market value that you get as of that day, or until the day they take the property, and then that's the date that will always apply for the valuation. So there is a lot more work than you would think when it comes to valuations. There's a lot goes on behind the scenes as well. Valuers will always, where they can, go and visit the comparable sales. So it's not just going to look at your property, it's actually going to do a drive-by of comparable sales. And I can assure you a bank valuation doesn't do that. So the perception of cost in valuation from a layman's point of view is quite different to what actually happens in a case. Naturally, if you're going to have an acquisition as well, you deserve the best. You deserve somebody who is experienced, and it is true to say that that takes many years of practice, and that the more experienced practitioners probably will charge more because they can, because of their knowledge and expertise. But also using someone who is knowledgeable means that you cut through a lot of things quicker as well, that they understand things better, they know exactly how the act is to be applied. Many times as well, valuers will need, or we as lawyers need to advise the valuer. We need to instruct the valuer on a certain basis. How are you going to value this land? The first question you always ask is, what's the highest and best use of the land? If you have land that has potential for it being rezoned in the future, or if there's an issue about what the zoning is because all of the land has been zoned for the public purpose, which, let me just give you an example, is say your land is zoned as a park. We have to say, well, we obviously don't apply that zoning. What is the zoning? And so sometimes it's not as obvious, because if you look around the area, you will see there could be high-rise, there might be a mix of zoning that allows just for townhouses, there might be various different, could be enterprise zoning if you're anywhere near Western Sydney, there could be all sorts of complexities. So frequently we need a town planner as well. And what the town planner says then informs how we instruct the valuer. So if you assume land is valued as just residential with no potential, it's going to have a very different value than if you instruct the valuer to say, well, assume that you can put a high-rise with 400 apartments on it. So the town planner's evidence can sometimes be even more important than the valuer's evidence, because the valuers may agree that if you can actually put 400 apartments on a property, how much it's worth, or they can be within a fairly close range. So a lot of cases don't come down to the valuer's evidence, but to the town planners. So there was a court case where they said, even though the Act doesn't spell out town planning advice or any other experts, so far as we need that expert advice for the valuer, then it is covered also under the Act. So the good news is the town planning fees are covered. Occasionally we need other experts. Flooding can be a common one these days, and so a hydrologist would also be needed, as well as a town planner. Maybe not as well as, or instead as, but there are other experts. A lot of those experts do require payment upfront, but some do not. So in terms of the costs for those experts, again, the same thing applies with the government looking at it and saying, well, was this reasonable? Did you really need to get a hydrologist? Did you really need to spend $10,000 in doing that? And my job as a solicitor is to make sure as best as I can that you are not out of pocket. And so commonly we will tell the acquiring authority, look, we have to spend this money, and a lot of the time we will get good comfort because they'll come back and they'll say, yes, we get it, go for it, that's fine, we'll reimburse it, and sometimes they don't. So again, it's not as straightforward as it may seem. So when you read on online on Google or on AI that yes, your costs are covered, there is a lot that goes on behind the scenes that you just need to make sure that you are very mindful of, and that you make the right decisions on your case. You get the right experts. That's certainly the most important thing to do, and you work within whatever parameters you've got.